Now for a different view. Brenda Wright is the director of the democracy program at Demos. She has led many progressive legal and policy initiatives on voting rights, campaign finance reform, redistricting, other electoral reform issues. She's argued 2 cases before the United States Supreme Court. That is Randall versus Sorrell, I believe is how you pronounce it, campaign finance, Young versus Fortas, voting rights, and I can go on, but I'm going to let her speak.
Thanks. Thank you. Thank you, and thanks especially to the conveners of this really amazing conference. It's a privilege to be here with all of you and to be part of this fascinating discussion. I want to start by saying a couple words about my organization, Demos, just so you know where I'm coming from. Demos is, we think of it as a think and do tank. It's a national nonpartisan organization that's driven by several core values and goals. A robust and vibrant democracy that's characterized by high levels of political participation and civic engagement. A more equitable economy with widely shared prosperity and opportunity. And an empowered public sector with the capacity to work effectively for the common good. We work a lot in the democracy program on overcoming structural barriers to registration and voting and to fair representation. And this includes work in a variety of areas, including making sure that voter registration is readily available at public agencies, as federal law requires, promoting pro-voter reforms, such as same-day registration to bring more people into the process, working on problems like prison-based gerrymandering, seeking greater civic engagement of immigrant communities, and many other projects and programs. We have been asked as panelists to say something about our views on an Article 5 convention and how we view that and just our perspective on it as a solution to the problems that we've all been talking about. And I guess I would describe my perspective on the question as one of sympathetic skepticism. So I want to talk first about the sympathetic side of what I have to say about the calls for a Article 5 convention. First of all, I fully agree and am in accord with the idea that Citizens United and the Supreme Court's campaign finance jurisprudence more generally has been very damaging for our country. Demos, my organization, was engaged in the court battle to oppose the unleashing of corporate independent expenditures in elections. We submitted an amicus brief along with probably many other folks here. Our brief did get quoted in the opinion. Unfortunately, it was the dissenting opinion. That's the sole comfort that's available to us reformers these days in the Supreme Court. I have, in a number of forums, since that decision was handed down, talked about my disappointment that the Roberts Court has given us the Anatole France First Amendment. It's a First Amendment that, in its majestic impartiality, permits giant corporations and ordinary citizens alike to spend as much money as they want on elections. And so, I really fully agree with all those here who have noted the violence that's been done to the First Amendment by that decision. And other Supreme Court decisions in recent years we could talk about have similarly impeded the goal of a fair and participatory democracy, from Bush versus Gore to Randall versus Sorrell, which struck down Vermont's spending and contribution limits, to the Crawford case, which upheld restrictive photo ID requirements in Indiana, to this term's decision striking down important provisions of the Arizona Clean Election Law. So on these issues that are so fundamental to our democracy, I think it is right for people to seek a constitutional amendment to undo the damage of decisions like these. And I also understand, in addition, the overwhelming sense that our current political system is broken and can't provide for the necessary conditions of accountable and responsive government. And not just because of the depredations of the Supreme Court, but also because Congress is gridlocked into its current dependence on moneyed interests and is disinclined to reform itself. So that's the sympathetic part. Where does the skepticism part of the equation come in? There are several points that I've pondered in thinking about the call for an Article 5 convention, and I really would pose these more as questions rather than as definitive views that I'm not willing to discuss and debate. I'm not going to start with the very basic and already discussed concern about a runaway convention, although I'll return to that a bit later because I do fear that some profoundly undemocratic measures may be among those most popular with such a convention. But first, though, I'd like to ask about something that I think is equally fundamental, which is this. Does the call for a constitutional convention, an Article 5 convention, rest on some potentially unwarranted assumptions about how the process of the Constitutional Convention itself would stand apart from and above the broken politics that it is really a reaction to? And let me explain what I mean by posing that question. It's easy enough to look at the squabbling, the rancor in Congress, the grip of special interest money, and the unhelpful role the Supreme Court has played, and to look toward a different and previously untried political convening under Article 5, and to hope that it would be radically different and free from those problems. And the question I really want to raise is that hope fully warranted? The question requires us, I think, to think a little bit about how the delegates to a constitutional convention will be selected and how the convention itself will run. We've heard about some really great ideas about that this morning, but the text of Article 5 provides absolutely no guidance and no requirements that are binding on states in how that process would be done. And I think that a lot of people may imagine that at every state house there is a closet somewhere that's marked open in case of Article 5 convention. And you open the closet and out marches a phalanx of Daniel Websters and Mr. Smiths who have been kind of preserved in some sort of political purity gel all these years, and they'll be ready to sort of march off and gather in Philadelphia or Washington or wherever and just nobly and calmly become the second founding fathers. The problem is that there really is no con closet. Instead, as we've heard, each state will decide for itself, without any precedent or guidelines, how to choose its delegates, how many delegates there will be, whether the electorate has a say in choosing, whether the delegation will operate by majority vote, et cetera. And the enormous power that delegates to such a convention will wield, I would fear, and I just ask this question, is that going to be likely to escape the attention of the same forces that have been at work in our political system generally? The effort to influence delegate selection state by state, I think is in all likelihood going to be a pitched battle on a 50-state front, and I'm not sure that it's likely it's going to be unmarked by partisan bickering, bitter disputes about the rules and procedures, and special interest influence seeking to control the process. And I think that if we can talk about those questions and if folks have some answers to those concerns, that's something I would really be interested in hearing about here. I think that the very fact that there are going to be disputes over these rules means that people are going to be back in the courts, because that's certainly been our recent political history. The Supreme Court might decide to stay out. It might decide to intervene very aggressively. We really don't know, but if part of the impetus for a constitutional convention like this is to get away from the trump card that the Supreme Court has been playing on our political system, I think, again, we have to ask, will we really be escaping that trump card that the courts potentially could play here? And I do want to go to the question of substance just a little bit. In some of the reading I was doing about this whole process, I was surprised to find out that back in the late 1960s and early 70s was when we actually came closest to having the requisite number of states call for an Article 5 convention. 33 states applied for a constitutional convention, and the topic that they wanted to address was whether to overturn the Supreme Court's one-person, one-vote doctrine in Reynolds versus Sims, which was very unpopular among a lot of states when it was first announced by the Supreme Court. And so that experience, that history, lends some support to the concerns that I have about how a convention, if it cannot be limited in the topics that it takes on, how it would really respond and respect the rights of democracy and the fundamental rights of representation. I think that I want to just return, before I conclude, to the sympathetic side of my perspective. I do understand the potential value of a constitutional amendment campaign as a means of mobilizing public sentiment toward fixing serious problems in our democracy. I believe that a lot of those goals can be achieved by a targeted campaign toward an amendment directly targeted at campaign finance and voting rights through the established procedures that have been used on other occasions to amend the Constitution. But I am very eager to hear how proponents of Article 5 Convention view the questions that I've highlighted, and at a basic level, I think supporters of any kind of amendment process have more interests in common than they have issues dividing them. So I'm very happy to engage in this discussion about these important issues that have been framed so well in this conference. Thanks very much.